All rise. The Court of Appeals Division 1 is now in session.
Thank you very much. Please be seated. Thank you. This is the time set for argument in Helen versus Helen, our cause number 1CA-CV130227. Let's go ahead and begin with introductions of counsel. For the appellant.
Good morning, Your Honor. Tom Cooley on behalf of the appellant.
Thank you.
Your Honor, good morning. Attorney Douglas Gardner. I represent Stephen Helen, who is the respondent.
Thank you very much. Let me go through a few preliminaries. First, let me advise counsel that the panel has read your briefs. We've reviewed pertinent portions of the record as applicable. We're familiar with the issues and the facts in this case. You might wish to take that into account in your argument today. Each side has 20 minutes, and so if the appellant would like to reserve time for rebuttal, when you go to the lectern, let us know, and we'll try not to poach on the time. Now, we have a cross appeal here, and usually most appellees or cross appellants end up just using their entire time at once. We are audio and video recording these proceedings today. So when you go back to the lectern when you first go there and then go back again, if you would please re-identify your name, restate your name. That way, if anyone wants to listen or view the recording, they will know who's speaking. And I think with that, we'll go ahead and begin. Sir?
Thank you, Your Honor. May it please the court, we have three issues to present today. I'm going to try to spend most of my time on the one that I think is the most interesting legal issue, which is the proper characterization of community property interest in a specific insurance policy that was at issue in this case. The two remaining issues, though, first, how to properly value community property in terms of waste is a factual dependent issue that ordinarily we would give quite a bit of deference to the trial court. But in this case, there is absolutely no evidence in the record that supported the trial court's determination that a specific business had been sold for fair market value. And then, of course, last is the trial court's award of spousal maintenance for a limited term and in a limited amount. And the trial court went through its order and found all of the factors supporting that award, and we, of course, will argue that that was well within the court's discretion. Okay, so community property. It's a creature of statute, and the legislature has said that property acquired during the marriage is ordinarily community property. There is no question that this policy was acquired during the marriage. Now, ordinarily, when people say that phrase, they're thinking of time. They're thinking of when. But the court, the Supreme Court, in both Jurek and Van Loan, has said that when is not the only issue. You must first ask when, and then you must ask how. How was the property acquired? And this is the word that we're going to focus on, is acquired. And if it is acquired through onerous title, meaning that the community paid for it with its own funds or with its own work, then it must remain community property. Now, if it's acquired through lucrative title, meaning it was a gift or an act of Congress, then fine. It can be separate property. But in this case, there is absolutely no dispute that this policy was paid for in its entirety with onerous title.
Doesn't that get us to there's a when and there's a how, but really under Berg and some other cases, the post-date Flowers, isn't there an aspect of what is this policy attempting to replace or to supplement? And isn't the argument here that this is a very unique type of disability policy, and that it was essentially providing when Dr. Helen became disabled, it was providing replacement income. And that's income after the petition is filed. It belongs to him.
The what is a very interesting question, Your Honor. I don't know where it came from, but it shouldn't be there. It is not there under the statute.
Well, we're an intermediate court of appeals, and we have to follow the law as established by our Supreme Court. And it strikes me that Jurek and cases that apply Jurek have resolved that issue, and they do take into account a what.
Jurek does not. Jurek simply does not. Jurek is a very clean 3-page opinion, and it does not talk about the what at all, in which I take it as the concept being, well, the intent of a disability policy is to replace future income. That does not come up until post-Jurek in Costco.
Yeah, right, Costco, yeah.
And in Costco, I mean, it's a fascinating opinion, but again, it's very, very short. And it does not stand for what happened in this case. The Costco opinion actually was a lucrative title opinion, read correctly, because it was federal benefits akin to workers' compensation benefits, and there was probably a federal preemption issue anyway. But yes, Costco does start talking about this notion of intent. What is the intent of it? But that really does not come under the statute. Now, more directly, however, even if this court is going to continue the line of Costco and Hatcher, which of course we don't believe it should, in those cases, they are talking about the intent to replace future work income, future labor income. And this policy doesn't do that. So even if Costco and Hatcher...
How does this policy not do that?
Because it's an own occupation policy, and the evidence in this case is absolutely uncontradicted, that even after this policy's benefits are triggered and it is paying, Dr. Helland is free to go work and make even more money, and he did continue to work and make even more money.
That's the
than
great
he did
beauty
prior.
of these owner occupation policies. He could take and become trained in a different, I mean, he could have become a ditch digger for all, but he's still going to get that income as an anesthesiologist under this policy. But that doesn't, the fact that he was able to then retrain and go into another line of medicine doesn't mean it transforms what that policy was designed to do.
That policy was never designed to replace income. I'll give you the example from Jurek, which was a personal injury case. And we'll use your ditch digger. Ditch digger loses his arm. He has a perfectly good personal injury claim for loss of his arm. But if he retrains as an accountant and now is making more money than he ever would have as a ditch digger, he has no claim for future lost income. He can't prove it. And that's where we are in this policy. There is no future lost income. So even if you take Hatcher, and Hatcher's the most express one for saying, well, a disability policy is intended to replace future lost income, it doesn't fit the facts of this case.
Well, if you take the word lost out of that statement, isn't that the problem here? The disability policy at issue here was to replace future income that Dr. Helen could otherwise have earned if he had been able to practice as an anesthesiologist.
No, I don't think that's accurate, Your Honor. And may I point out one defect in the factual record? The policy is not before the
I
court.
was going to ask you about that.
Yeah. This leads me to the presumption issue. The presumption is community property, and the burden is on Dr. Helen to prove that this falls out of community property. And Dr. Helen did not put the policy in the record. So to the extent that we're guessing as to exactly what the policy says, that defect falls on Dr. Helen, not my client. Now, what is in the record, though, is the undisputed testimony that this policy would pay regardless of how much income he did, in fact, continue to make from his labors. So therefore, it cannot be a lost income policy. There is no condition in this policy for proving lost income, and there is no condition subsequent for terminating the policy because of lost income. Whereas in a true personal injury situation like Jurek, there would be. If you can't prove a disability that limits your income, you don't get workers' compensation. You don't get lost damage, lost future income in a personal injury case.
Well, if your position is that the disability policy proceeds are not replacement income, how would you characterize them?
I would characterize them as a contracted risk with an insurance company. Your Honor, insurance policies are a beautiful thing. Insurance companies have the ability to define the risk that they are insuring however they want. And the evidence in this case is the risk that was insured was the ability to be an anesthesiologist, period. That was the only risk insured. And the evidence is uncontradicted that Dr. Helen can never be an anesthesiologist again because he contracted a chemical sensitivity. But that doesn't mean he can't earn billions of dollars doing other things if he so wishes.
So, but he is disabled.
He is disabled from
to practice
being,
as an anesthesiologist.
Yes, and that is the only risk that was insured. It is not lost income risk.
So how would you characterize these proceeds?
Yeah.
Is it like a wager? I mean,
Yes, it essentially it is. It is a risk that was contracted for where the insurance company assumes that only 1 out of 1,000 people will incur the ability not to practice their current profession, and they spread that risk among a pool of people. And
we don't have the policy, but I'm presuming that the benefit was calculated based upon income history for the insured.
Again, the policy is not before us, but I would not have any basis for contradicting that presumption on this record, Your Honor. But that's how they calculate the benefit, not how they calculate whether the benefit is due. The benefit became due regardless of how much it was going to be, because Dr. Helen proved that he could not practice anesthesia. And the burden of that, if you want to call it a disability, fell on the community. It doesn't fall on him now. There was a short period of time, the evidence discloses, where there was a loss of income while he retrained so he could be a pain management specialist. But that whole loss fell on the community, not on him going forward now.
But the community had the benefit, of course, of the policy payments as well.
Yes, but Your Honor, I really don't understand this argument. That just means the community made a good bet. It doesn't mean that the community somehow loses its community interest because its investment turned out well. If they had bought an annuity,
It turned out very well.
yes, it did. But think about this. They were in their 40s when they bought this policy. If they had been in their 50s instead, it probably would have been prohibitively expensive. But if they had taken their money instead and gone and bought an annuity when they were in their 50s and had said, geez, let's go buy this annuity in case something happens and Dr. Helen can't be an anesthesiologist anymore, there would be no question before this court. That annuity would be community property. It wouldn't even be an issue. So I don't think that you can get to the court's conclusion here if you follow either Jurek and...
I think I'm following you. Excuse me for interrupting, but I think what at least I'm struggling with is that even though this isn't perfectly crafted to replace specific lost income that is proven year after year on some basis or through some mechanism, even granting that, it's closer to lost income than it is to an annuity.
Perhaps. I don't know how to measure that line of where it's closer to. It's its own type of policy, Your Honor. And the point is on this record lost income simply does not make a difference. There is no loss of income. And that's the evidence.
Well, there's a loss of income from being an anesthesiologist because he isn't making any anymore.
But that's the lost future income requires that you show a net loss. That's the retraining as an accountant versus a ditch digger problem. You can't claim he couldn't get workers' compensation for disability. He couldn't get in a personal injury action. He couldn't recover for lost income because he doesn't suffer any net lost income. Okay, I want to talk briefly during my remaining minute or two here about this issue of the business. Again, ordinarily this is a factual issue, waste, and we would defer to the trial court. But in this case, there is absolutely no evidence in the record that supports the trial court's determination that there wasn't waste. The closest that there is was Dr. Helen's expert witness who said, yeah, this business got sold for $189,000 less than its tangible asset value. Now, that is the definition of waste, and the question then becomes, who does the burden shift to prove that the community was not damaged by that? And that again would be Dr. Helen. Once we prove that the asset was necessarily sold for less than its value, Dr. Helen must prove that there is not waste.
Well, that wasn't the expert's only opinion, was it?
Oh, no, he had many others. There was
It wasn't his principal opinion was that the practice sold at a market value.
No, he never uttered those words. Mr. Pinkow's testimony was very interesting because what he said is, I made no effort to try and value this business. My only job is to critique Mr. Gorman's valuation, but I made no effort at all to try to value it. But on cross-examination, he conceded that the value had to be at least $189,000 more than it sold for. He never got to saying, no, that was fair value. The only person who even tried to claim it was fair value was the purchaser. Well, the purchaser had to admit that, geez, I negotiated this because I knew that Dr. Helen had to sell. Dr. Helen had to sell because he had lost his medical license. So that is waste. Now, how you can conclude that it's fair value when you have no definition of fair value that can be met? Because fair value would require a willing buyer and a willing seller, neither under any compulsion. Standard definition of fair value. And they can't get there here. They have to admit that it's $189,000 under. Now, I realize that spousal maintenance is going to be presented, and I'll reserve my remaining 3.5 minutes, if I may, for rebuttal remarks, if the court doesn't have any other questions at this moment.
Your Honors, Attorney Douglas Gardner representing Steve Helland. There are 4 issues before the court today: the disability policy, the marital waste claim, spousal maintenance, and my client is asking for attorney's fees on the appeal. The first issue, and I would like to, if possible, try and reserve 1 minute or so for rebuttal on the spousal support issue, but if we are having a good time and blow right through that's acceptable as well.
We will be.
A good time.
I'm looking forward to it. Let me spend the majority of the time on the disability insurance policy. This policy was to replace future income, not lost income. The Mr. Quigley's constant emphasis on the word lost is just not applicable based on the law in this case.
It's not tied to any ascertainable proof that income has been lost or that future income would have been earned.
I would agree. The measurement for, if it's income related, then it's sole and separate after the date of service, and that's something, this is income related. It doesn't have to be lost income related or anything of that nature.
And where would we go in the record to find the best information about this policy and what it was designed to do?
Both parties testified about this policy. Both parties testified that this policy will end when Dr. Helen turns 65. That's important. end. That's retirement age. Both parties agreed that if this and Mr. Helen has to be reviewed annually. He has to go through a medical exam. If he's ever found to be able to practice anesthesiology again, he would lose this income. And so because of that, it is to replace his income. Both parties agreed that if at any point that he started practicing anesthesiology, this would go away. So this is to replace his income. It's important also that the Jurek line of cases, which distinguish that things brought into the marriage include somebody's body, and so in Jurek the injury to the body. In this case, Dr. Helen brought into the marriage his body, his earning potential, his medical degree, and all of that came with it. And so while the bet or the wager may have been paid with money during the marriage, it was a wager or a bet on his earning ability and his body and his medical degree that he had brought into the marriage. And a claim that they can buy his future earnings as a community asset, without being too blunt, that's slavery, buying somebody's future earnings, and that is not what the Arizona divorce law and community property law entails. Mr. Quigley brought up a claim that one of the cases talks about a federal benefit, and he tried to distinguish that and said, well, this is a private policy. The law doesn't support that claim. Many of these cases talk about whether this is purchased by the client or by the parties, the employees, or paid for by the employer, and the result would be the same. In this case, they purchased it themselves, but when somebody's out earning a living and then part of the benefits they receive are contributions to other what we would call perks, those are also considered income to the parties. And so whether or not it's a benefit that's given through employment, even if they don't have to pay for it, or if they pay for it, that distinction doesn't apply or make any sense in the law. I wanted to address the good bet discussion that Mr. Quigley brought up. People can also buy life insurance. Now, the difference, I guess, the distinction in life insurance and this disability insurance is you can only die once, whereas you can have each month on a disability policy, each month is measured as to whether or not you can work that month, and so there's multiple instances of there's multiple payouts of this good bet, as Mr. Quigley termed it. It would be absurd if the parties came in and had a divorce, and at the time of the divorce, they were both alive because they're getting a divorce, and there was some evidence that said, we have put money into a term life insurance. Now I'm going to distinguish that from a whole life or a universally life that have some asset value to it. But if the party said, but I want to make sure that if you die 10 years from now, we paid a portion of that life insurance policy during the marriage, that's simply not the case, because it's measured each month you pay it. If you're alive at the end of the month, everything you paid is now wasted, it's gone. You purchased comfort, you purchased security. And so it's the fact that if the person were to get divorced and then 10 years later die, it's those additional 10 years of payments, or really rather the very last month of payment, that secured the funds of that life insurance policy upon the death of that party. And so in this case, the community purchased comfort and security, and they experienced comfort and security. In fact, they benefited quite well during the marriage from that comfort and security, and they received the benefit of what they purchased. Now, once they're divorced or after the date of service, because this replaces Dr. Helen's income, it is his sole and separate property under the law. And the law is quite clear.
Before we go,
Please.
Go beyond that point, although I don't think we touched on it that much in the first half of the argument with Mr. Quigley. As I recall from his briefs, one of the arguments he's making is that we should simply look at 25211A, which of course is a foundational statute here, and it basically says if the property is acquired during the marriage, it's going to be community property. Here we know the initial property, the policy, was acquired entirely with community funds. Why doesn't that retain its character then throughout?
Well, first of all, let's read the Costco case, which very clearly addresses that. But second of all, there's a distinction between income and property. Now, Mr. Quigley would like to call this property, and he'd like to treat it as an asset. But this is income. This is replacement income.
Well, it's not income like we go out and, we're all doing our jobs today and we're earning income. It's not like that. It's something else, and it was bought beforehand with community funds. It's a different kind of. It's the result of property, isn't it?
And I'd say no. What he's actually receiving is income. This is income to replace the income that he would have been able to earn had he been able to continue practicing.
Anything in the record as to whether he pays income tax on it?
I'm not sure, and I would say that the taxability would not necessarily. Arizona law would not necessarily follow the IRS determination of how it's taxed as to whether it's considered income for community property purposes. Now, there's several. Mr. Quigley tries to distinguish the Costco case, but this case is remarkably point on. While for vanity reasons I'd like this to be a published opinion, you may not need to publish this opinion because there's not much new in this case compared to what the court did 34 years ago in the Costco case. In there, they said, we agree and hold that disability benefits should be treated as a separate property of the receiving spouse after a dissolution. They are not contingently payable upon the occurrences of specific future circumstances, such as with distinguishing the Van Loan cases, that they are not payable based on specific future circumstances, such as the disability benefits. Again, it's those future circumstances, the continued disability, the continued ability to earn income as an anesthesiologist that gets that. Continuing on, we think that there are significant differences between retirement or assets and disability benefits.
Say again what page you're on, please.
This is page 105 of Costco. It's in the paragraph starting with disability benefits.
I'm with you.
And whether paid by the employer or the employee, and we talked about that argument. Skipping down a little bit in that same paragraph, although the entitlement to this benefit may be attributed to employment and thus have a community origin, the money so expended does not produce a community asset subject to division at dissolution. Again, distinguishing income from assets. This is not an asset, and therefore the statute that assets acquired during the marriage are presumed to belong to the community. That would not apply to this non-asset. This is income. The end of that paragraph, just as the post-dissolution earnings of a spouse are separate property, internal citation, so then is it logical that post-dissolution disability benefits are separate property. So very clearly, a case very, very much point on here with this case points out that this is not an asset. It should be treated separately as income. I would, if there's any other questions on that, if not, I'll move on to the other. All right, the next issue, Your Honors, is the waste claim. Let's start out with ARS 25318C. This statute, when setting forth the ability of parties to make a marital waste claim, Section C starts out saying, this section does not prevent the court from considering, and then certain things including marital waste. And so this is kind of the highest level of the trial court has the discretion to do as it sees equitable, following the equitable, the requirement that property be divided equitably by the trial court. And so in this case, the trial court has the equitable right to divide that, and the court may consider, not must, not shall, not is required to, the court may consider a claim for marital waste. Now, the actual facts in this case is that the practice was sold to Dr. Brownsberger for $7,500. Wife agreed to the sale of this practice. In fact, wife's signature is the only signature from the sellers on the practice. She signed for herself and for her husband. Wife voluntarily signed the agreement, and she acknowledges that at trial. She reviewed and initialed each page and signed off on that. Wife did not look for any other potential purchasers. Wife made no efforts to try and market this. Wife made no efforts to try and sell this to anybody else. The practice was sold by wife after the date of service, after they had filed. And so if we look at this, on the date of service, they had an asset. Subsequent to that, the parties agreed. The preliminary injunction prohibits the parties from selling something without an agreement. They agreed to sell this at that price, and they sold it. The two experts did testify that
It really was kind of a fire sale.
I don't know that it was, and the testimony doesn't support that either. If you look at it, Dr. Brownsberger, who purchased it, said he came in and offered a lower price. He testified also that he didn't purchase it at what he believed a fire sale. He thought it should have sold for less. He was aware of the instances, but he indicated in his testimony he did not believe that he paid less because of Dr. Helen's situation. So he made an offer. The Helens both wanted to sell it for more. He wanted to buy it for less. They negotiated and found a number in the middle. Now, both experts testified that the best way to value a practice is to look at what it sold for. One interesting point is that between both experts, very well recognized experts across the state of Arizona, all of them together, both experts together, only found 3 other anesthesiology practices that they could compare this to. This is simply not something that sells very often. And so if it's sold for less than somebody thinks it should be, that's simply because there is no market. The testimony talks about that, the world of buyers for this property, not anyone can buy an anesthesiology practice. You have to be a doctor. Most doctors don't practice anesthesiology, so you have to be an anesthesiologist. Then you have to be willing to live in northern Arizona, in Shoalo, Arizona. Most doctors would rather earn more money living down here than less money living up north. And so it just narrowed down the field where there really was not very many buyers available. It is that lack of buyers that reduced the value of the practice, not any fire sale type issues related to the practice. Now,
What about Mr. Pankow's testimony as described that it was sold for $189,000 less than
than an asset value. So if you look at the taxes and it says here's what the assets are worth, but then there's the issues of depreciation and other things. And so just because you have a car that is listed as an asset of X amount, it may not have depreciated on a straight line basis. They may have driven it off the lot and it lost value much more quickly. And so both, Mr. Penko.
the Kelly Blue Book, isn't it?
Well, but if you compare it to if you go off the asset value, which is based on the tax return, you don't use Kelly Blue Book. You go off the depreciation schedules, which are straight line.
Mr. Pankow's testimony was related to asset value from tax returns.
That's how they testify that's how they calculate the asset values based on their review of the tax returns. And so they looked at the tax returns, and that's what they said that asset value is. And he acknowledged that it came in $189,000 less than that.
So Dr. Brown bought assets less than they're listed on the government rolls, and without any goodwill.
He purchased it at a mutually agreeable price that Dr. Helland and Mrs. Helland agreed to sell it to him, and it's important that they had this opportunity to negotiate. Ms. Helland had the opportunity at any point to say, you know what, I choose not to sell it to you. I'm going to hold out and sell it to. We're going to find another buyer.
I understand.
We're going to list it.
They were really kind of over the barrel. They were lucky to have one buyer, sounds like.
Well, if there was only 3 of these sold by anyone in the last 40 years, I think it was miraculous that they sold it. They may have had to strip it down and sell it for the component parts, sell the real estate, and then they would have medical equipment that would have not sold at all.
Yeah, that would have been a whole lot less. I think we're expressing some agreement here, but maybe not agreeing on the legal significance of it. And I'm just trying to test it. I haven't formed a final judgment here.
Sure.
But it seems to me that where you have a limited market, you kind of have to take what you can get.
You do, and that.
But
apologize.
let me just finish this one point. they wouldn't have been in that position but for the doctor's bad acts.
And I would argue that no matter when they tried to sell this, if they would have retired 2 or 3 years later and tried to sell it, there still would have been a limited market. There's very few doctors who want to live and practice in the rural outlying counties of northern Arizona because of the much lesser income that they can earn in those places.
So is basically your argument that even if we were to assume Dr. Helen committed waste, the price that Dr. Brown paid for the practice was reasonable?
My argument is there was no waste. It
Right,
was,
I understand that,
It was sold at a reasonable price. It was sold by wife at a reasonable price. At no time prior to the divorce.
Price was still reasonable, cut right down to the bottom line.
I think the price was reasonable. And if it wasn't, Miss Helen could have asked for more. Miss Helen could have made some other things. And so if there was waste, it's just as much her waste as his. Now, moving on really quickly to the two final points here. As to the spousal support, Miss Helen received approximately $2.5 million to $3 million worth of assets. She has these assets. She has, under case law, she has an obligation to make these assets income producing. And the court recognized that some of these assets were a very large home and some other assets that were not immediately liquidable or could not immediately be used to produce income. However, awarding her spousal support for 7 years exceeds what she would need to meet her reasonable needs and to be able to to turn this substantial nest egg she has into income producing assets and use that to support her.
How was the 7 years determined? Did the judge explain how he got there?
The court never indicated what the 7 years was for, but I think it's very interesting that the 7 years falls short of her retirement age. She'll be less than 65 when the 7 years ends. And so it was not based on that she needed spousal support until she reached retirement age. It was just some arbitrary amount of time. What that tells me is that the court realized that at some point, perhaps 7 years from now, she would have the ability to use these substantial assets to produce income. I would argue it's an abuse of the judge's discretion to require 7 years to turn $2.5 to $3 million of assets into income producing properties. In my last minute, I do want to address the issue of attorney's fees. We are asking for attorney's fees on this appeal. The two issues under ARS 25-324 are the income and assets of the parties and then the reasonableness of the positions taken. They each received approximately half of this very large estate, so their assets are, their financial situations is substantially similar. We would argue that bringing this issue up on appeal primarily, and as Mr. Quigley admitted, the primary reason we're up on appeal is because of the disability policy. Because the case law is so clear, primarily the Costco case, which is remarkably similar to this, we believe it's been an unreasonable position maintained throughout the trial and throughout this appeal, which brings us here today. And primarily based on that unreasonable position taken by Ms. Helland, we are asking that the courts award Mr. Helland, or Dr. Helland, his attorney's fees on appeal. I've got 6 seconds to answer any questions. Thank you.
Thank you very much.
I want to use my first minute or two here to address some of the questions that the court had for Mr. Gardner. First, Judge, you asked about the taxability of these benefits. And I want to address this because it shows how fundamentally unfair what the court did is. These benefits are non-taxable. We cited that portion of the record to you. It's transcript 3, page 87, lines 3 through 14. And what the court then turned around and did, instead of giving the parties essentially half of the community property, he gave this $1 million current value asset to Dr. Helland and then turned around and awarded spousal maintenance. Whereas if he had simply divided this asset equally, there would have almost certainly been no spousal maintenance award. Well, what's the difference? Not only does she get shorted, she didn't get anywhere near half of the value of this policy, but she has to pay taxes on that income. Whereas Dr. Helland is using the disability policy that he doesn't have to pay taxes on to turn around and pay her spousal maintenance, and he gets a taxable benefit for it.
Does he not pay taxes on that because the community paid for it with after-tax dollars?
That is correct. And he started to say that in the record. He said because it's after, and then he cut off. But that is the legal reason, is because it was paid with after-tax dollars. Next, I want to address this question of whether Costco and Hatcher are limited to lost future income. And the quote out of both of them is yes. Here's what Costco said, and I apologize, I don't have a pin cite for you, but it's only a 3-page opinion. What payment for disability insurance produces is coverage for the individual spouse against the risk of disability and loss of future earnings ability. There is no loss of future earnings ability here. And remember, Costco is not a disability insurance policy. It's a federal benefits policy. Hatcher said the same thing, 1996. Here's what Hatcher said about Costco. What Costco and McNeil establish is that payments which represent compensation for post-dissolution earnings of the injured spouse is separate property of that spouse. These payments are not compensation for future lost earnings. He has no future lost earnings.
If he had been unable to be retrained, we wouldn't be having this discussion, correct?
Well, I would certainly lose under Costco and Hatcher, Your
Okay.
Honor.
So really, it comes down to these unique policies of the owner, the specialty policies that the insurance companies were writing back in the 80s or thereabouts, early 90s.
If I can say yes, but, I'll say yes, but Costco and Hatcher shouldn't have been written the way they are. Their actual holdings are completely unobjectionable in both cases. But their analysis, there's some loose analysis in there. Jurek is the case that gives the analysis. Was this acquired with onerous title? That's the question. The answer is yes. It's community property. And Bew, if I'm pronouncing that right, the workers' compensation case says the same thing. I see I'm out of time, Your Honor, and thank you for your consideration. If there's no further questions, I will sit down.
Well, thank you very much. We appreciate your briefing and your argument today. We're going to take this matter under advisement. We will issue a decision in due course. I would ask the bailiff to make sure that the files here go back upstairs. Gentlemen, thank you very much for your argument.